नमस्कार दोस्तों, आज हम जीएसटी लॉ के अंतर्गत कुछ वन टाइम बेनिफिट्स दिए गए हैं, प्रोवाइडेड वो बेनिफिट्स को लेने के लिए या उनका फायदा लेने के लिए जो कंप्लायंस करना है वो 30 जून 2023 तक करना पड़ेगा। वो वन टाइम बेनिफिट्स की आज हम जानकारी लेने जा रहे हैं। फ्रेंड्स, टुडे वी आर गोइंग टू डिस्कस सम वन टाइम बेनिफिट्स गिवन अंडर जीएसटी लॉ through notifications issued under section 148 and 128 of the GST law, and the compliance which is required to be done to avail the benefit of these notifications needs to be done up to 30th June 2023. So let us understand one by one. The first one-time benefit is given in respect of annual returns required to be filed under section 44. Under section 44, the annual returns are required to be filed either by the regular taxpayers filing the return under section 3B, in the form 3B, and number 2, composition taxpayers filing the return in the form GSTR 4 under section 10. Now, the benefit is that all the pending annual returns which are not filed till the date, beginning from financial year 17-18 till 31st March 22, all can be filed up to 30th June 2023 with a maximum late fees of rupees 1000 per return. So this is a huge benefit if we calculate the late fees otherwise applicable under section 47. Second, now a permanent benefit is also given by way of notification issued under section 128, and the late fees applicable for annual returns relating to financial year 22-23 onwards has been permanently reduced to a great extent. The benefit is that for taxpayers having aggregate turnover, please note I am speaking about aggregate turnover and not the turnover in the state or union territory. So for taxpayers having aggregate turnover during the relevant financial year up to 5 crores. So let us understand the difference between aggregate turnover and turnover in the state or union territory. Now, turnover in the state or union territory will include only the turnover of that particular registration: exempted supply, zero rated supply, intrastate supply, intrastate supply. Only the supply on which RCM is payable will not be included. But in case of aggregate turnover, the turnover of that particular taxpayer under all the PANs, under all the GST registrations. For example, Mr. A is having particular PAN and his turnover in Maharashtra is 2 crore, in Gujarat it is 5 crore, then his aggregate turnover will be 7 crores. So aggregate turnover is considered on pan India basis. This is the difference between aggregate turnover and turnover in the state or union territory. So for taxpayers having turnover during financial year 22-23 onwards of rupees 5 crore, maximum 5 crore aggregate turnover, for them the late fees is fixed at rupees 25 per day instead of rupees 100 per day, which was there by default under section 47. So this is a big relief. In addition to that, the maximum late fees has been fixed at 0.02% of the turnover in the state or union territory instead of 0.25% of the turnover in the state or union territory under section 47. So if we see the reduction or the benefit in the maximum late fees, it is 92% reduction is given. A huge benefit is given. This is a welcome step by the government. Now another category, for taxpayers having aggregate turnover during the relevant financial year of more than 5 crores but not exceeding 20 crores. The late fees has been fixed at rupees 50 per day, and the maximum late fees will be again 0.02% of the turnover in the state or union territory. So again, in maximum late fees, 92% relief. Now for taxpayers having aggregate turnover during the relevant financial year of more than 20 crores, no relief is given. For them, the late fees will be as mentioned in section 47, which is rupees 100 per day, subject to maximum of rupees 0.25% of the turnover in the state or union territory. Next one-time benefit is for those taxpayers who failed to file the return either GSTR 3B or GSTR 4 within due date. They have received the notice under section 46 for non-filing of returns. Even after that, they have not filed the returns, and as a result of that, the authority has issued or has passed the best judgment assessment order under section 62. What is the way out for them? The way out for them is that if they file the return for which best judgment assessment order is passed within 30 days from after the date of assessment order, along with the applicable late fees, interest, then that base judgment assessment order is set aside. This is the benefit given. Those maximum time period is 30 days after the passing of assessment order. Now, from Finance Act 2023, this period of 30 days has been extended to 60 days. Plus further 60 days. So the total extension will be 120 days, but this next extension of 60 days has been given subject to payment of additional late fees of rupees 100 per day. So in addition to the normal late fees, which is leviable under section 47, additional late fees of rupees 100 per day will be payable where the taxpayer seeks to obtain the additional benefit of 60 days. In other words, for first 90 days, no additional late fees. For additional 60 days, additional late fees of rupees 100 per day. But this extension of 120 days is though announced or laid down in the Finance Act 2023, it has not been yet given effect. So please note, the video is recorded as on 29th May 2023, and till this date this additional 120 days has not been given effect. Now the one-time benefit. What is the one-time benefit? The one-time benefit is that if the taxpayer against whom the assessment order, best judgment assessment order is passed under section 62 up to 28 February 28th February 23. Friends, please note, if the date of assessment order under section 62 is up to 28th Feb 23, then against those assessment orders you can file the returns up to 30th June 23 with applicable late fees and interest, and the assessment order will be set aside. So this is again a very welcome benefit given by the government. Next one is very important benefit which will help the taxpayers to restore their cancelled registration and to continue the business. It's a welcome step in the line of the agenda of the government, that is ease of doing the business. The benefit is that for those taxpayers where their registration is cancelled under section 29 by the authority as a result of non-filing of return, the provision is that in case of composition taxpayers, if the return for a particular financial year is not filed within 3 months after the due date, then the officer may, after issuing a show cause notice, can cancel his registration. And number 2, in case of tax filers filing return and in the form 3B, if they do not file the return for the consecutive tax period of 6 months or for consecutive 2 quarters in case of quarterly return filers, the officer may cancel the registration after issuing a show cause notice. So if in these 2 cases the registration is cancelled due to non-filing of returns, then the remedy available to taxpayer is that the taxpayer can apply for revocation of cancellation of registration, or in simple words, for restoration of registration, provided the application needs to be made within 30 days of the service of cancellation order. And this time limit of 30 days can be extended up to further 60 days only in case of special circumstances after making application to the higher authorities, and they can also extend this time period only for the sufficient reasons which is to be recorded in writing. Now, if this application for restoration of registration is not made within 30 days, and if the authority has also not extended the further time of 60 days, or even if they have extended, the application is still not filed, then for all those taxpayers, a one-time benefit is that they can apply for restoration of registration up to 30th June 23, provided the most important condition is that they need to file all the pending returns up to the effective date of cancellation of registration, along with applicable late fees, tax, interest and penalty levied if any, and they can get their registration restored. So this is again a huge benefit. In both these cases, that is number 1, restoration of registration, and number 2, filing of returns where base judgment or ex parte assessment order is passed under section 62, they can avail the benefit even though the appeal is filed against such order, appeal has been rejected, or appeal has been decided against the taxpayer. Hope you like this video. If you like the video, if it has made certain value addition to your knowledge and practice, please like the video, please subscribe to the channel. Thank you.